Estate planning, so beneficiaries, inheritance, and taxes. So estate planning considerations. Creating an estate plan will require you to make decisions about the following. So how assets will pass to your uh, beneficiaries, how you will minimize federal taxes assessed on gifts and estates, how you will minimize state taxes on estate or inheritance taxes, how you will use the gift tax exemption to transfer assets while you are still living, how the taxable estate will pay estate and inheritance taxes before assets are distributed to beneficiaries. So we're going to address these bullet points in the next slides. All right, so here are the sample estate planning documents that you would need to um, create or have created for you. You will need to seek an attorney and tax advisor to guide you in creating and filing the appropriate documents. The estate planning documents include the following: a will, a living will, the advance medical directive, and then the durable power of attorney for healthcare. And we're going to discuss all four. So the will. A will allows you to communicate your wishes. When you do not have a will, the state decides how to distribute your assets. This is called dying intestate. The elements of a will include the following. So there is a designation of an executor, the persons who carry out the provisions of the will, the beneficiaries, the person inheriting the assets, the instructions, information about how the person will receive the assets, and then the guardian, information about who will guard the children. The will designates the beneficiaries of bank accounts and real estate, since these are examples of assets that do not permit the naming of beneficiaries. Assets that permit the naming of beneficiaries and direct transfer of assets without involving the will include IRAs and investment accounts. You can avoid the probate process, associated fees, and certain taxes. However, assets that pass through the will typically go through the probate process, which is a legal process for settling an estate with or without a will. Assets that permit the naming of a beneficiary do not undergo probate. So these are the assets that are subject to probate, and then the assets that are not subject to probate. So retirement investment accounts that are missing beneficiaries or transfer of death instructions. So usually with the retirement and investment account, there's always an option that you can provide transfer of death instructions. Cash accounts that do not allow TOD or transfer of death. Real estate, personal property, and any asset held tenants in common. And then assets not subject to probate, because they usually allow for you to name a beneficiary. Retirement accounts, IRAs with a named beneficiary, trusts, insurance policy proceeds, investment, brokerage, cash accounts with transfer of death instructions, and then assets with joint ownership with right of survivorship. So in all these individual terms, real estate and investment and financial terms, you can always research on your own and get more information, because I don't want to give you an example or content for it, because you would always need to consult an attorney in terms of writing the will. And so it is much better that you get this information in terms of understanding it from a licensed attorney. The Advanced Medical Directive is a written statement that outlines the desired medical treatment should an individual become incurably ill. The United States recognizes two types of advanced directives, a living will and then a durable power of attorney. So the living will. The living will permits a person to specify the treatment he or she wants or do not want in case of a terminal illness, coma, and or near-death situation. The language might include determining whether there is a reasonable expectation of recovery and if he or she should be kept alive through medical intervention of any kind. The living will may specify pain relieving medication even if it shortens life. Living wills ensure personal control, but there is no guarantee. They are limited to people with terminal illness or who are expected to die shortly. Sometimes some doctors do not always follow living wills. Since they can be ignored, a durable power of attorney is necessary. So the durable power of attorney. The durable power of attorney for healthcare authorizes the appointment of another person to make healthcare decisions on one's behalf. The appointment of the other person may be a family member, but it can be someone else requiring a short statement. So I just want to stop right here before I go into the short statement. As you undoubtedly understand that as a single adult, these are some of the decisions that you have to make, and you have to know that the people that you appoint or include in your will or in your living will or in for your durable power of attorney, you can trust. It's very important because if you're not going to get married and you're going to be a single adult, or if you do decide to become married or pursue marriage, you got to be sure that that when you put this person in your will or living will or use as a durable power of attorney, that you can actually trust this person, that they won't just cut the cord. If you remember Tyler Perry's movie Diary of a Mad Black Woman, when the husband decided to leave his wife and stay with his mistress, he kicked the wife out of the house, but then he had later trouble, and which led him to be seriously injured by his client, and he was in a coma, I think maybe on life support, and the mistress wanted to cut the cord. She didn't want to think about it. She didn't care about it. Now here it is. The wife was so concerned about a man who just kicked her out of the house, about his life, that she wasn't willing to cut the cord. So it does make a big difference who you choose in life. Whether you stay single and you have a family member or friend you will use to make certain types of decisions, healthcare decisions, or a husband if you later decide to pursue marriage. So I just wanted to add that before we go into the sample statement. So here's a sample short statement, and it is courtesy of the Office of the Attorney General, State of Illinois. And this is a sample statement. So I hereby appoint, and then the name of the person, as my attorney in fact or agent to act for me and in my name in any way I could act in person, to make any and all decisions for me concerning my personal care, medical treatment, hospitalization, and health care, and to require, withhold, or withdraw any type of medical treatment or procedure, even though my death may ensue. I would like to think that if you got sick, I wouldn't be so quick to pull the plug. I would go off somewhere and pray to God about it, go read my Bible. I will consult more than one doctor. I would do all that I could before I make that final decision. So that's something that I want you to think about, because you are appointing a person as an attorney, in fact, as your agent, meaning that person has agency over you in your time of need, to act for you in your name, to make any and all decisions for you concerning your personal care medical treatment, hospitalization, and health care, and to require, withhold, or withdraw any type of medical treatment or procedure, even though your death may ensue. So if you're going to withhold or withdraw any type of medical treatment or procedure, you would like for that person to have at least get some kind of consultation. You can't choose people who are very hasty in their decision, in their decision making, that they have a record, a whole historical record of being hasty in their life. Don't make really thought out logical decisions. A person who is a thought out logical person will go and look the information up. Everything is on the internet. They will go and look the information up. They will do all that they could to try to find out about your issue before they say, okay, I have no other choice but to pull the plug. So think about this statement very carefully, because this is your process, this is something that you need to think about as you process becoming a single, becoming a dating single, or becoming a single pursuing marriage. Knowledge check, SWOT for estate planning. So what are your estate planning strengths? What are your estate planning weaknesses? What are your estate planning opportunities? What are your estate planning threats? One thing that is most important is that it doesn't matter how much money you have, you can still create an estate. Now, working with an estate attorney is going to cost you some money, right? But you can always create a basic estate plan, right? And so you may not know what your estate planning strengths are right now, or your weaknesses, or your opportunities, or your threats, because this may be a new concept for you. If because we always think just because we are maybe everyday workers and not rich people that we don't need an estate plan. You need a will. You know, it's important to have a will, and the will can be part of the estate plan. So I would encourage you to research this on your own, get more information, and understand, because if you have a house, you can name beneficiaries. You can create an estate. If you have any kind of asset or property or anything like that, you can still create an estate. So I just encourage you to think about that.